Hi, welcome to Jus Cogens, the International Law Podcast. This is episode 20. Today we are discussing the Ntaganda case at the International Criminal Court, where Bosco Ntaganda, former militia leader in the Democratic Republic of Congo, has been found guilty by the ICC of war crimes and crimes against humanity, specifically in the Ituri region of DRC in 2002 and 2003. Ntaganda was the first person to be convicted of sexual slavery by the ICC, and overall the fourth person the court has convicted since its creation in 2002. The case is currently in appeal, whose judgment will be announced today on 30th March, later this evening, a few hours after this podcast is released. Our guest today is Dr. Agnieszka Jachec-Neale, who has submitted an amicus curiae brief to the court in 2020, making certain observations regarding the meaning of the term attack and issues associated with it. Dr. Neale is an expert researcher and lecturer at the University of Exeter. Dr. Neale has over 5 years of experience working in field missions in Southeastern Europe, where she specialized in monitoring domestic war crime trials and in enforcement of human rights standards in emerging democracies. Her expertise lies in the areas of law of armed conflict, especially conduct of hostilities, military targeting doctrine, and its relationship with international law. Thank you so much, Dr. Neale, for joining us on the podcast. It's an absolute pleasure to have you today.
Thank you very much for having me. I'm happy to, to discuss the case and looking forward to seeing what the court judgment tomorrow will be.
Yeah, thank you for agreeing to do this on a very short notice. I realize this is just a couple of days, and I'm very grateful that you found the time to join me. So just to get the discussion going, can you tell a bit about the Ntaganda case? What's it about, and where its proceedings have progressed in the past few years? Give us an overview of the case in general.
Okay, Bosco Ntaganda is a Congolese by nationality, but was born in Rwanda, and he has taken part in various organizations during his career as a military commander, and lately he's been accused for the participation in various accused and sentenced now for participation in various acts that amount to international crimes, different types of international crimes, as a part of his involvement in patriotic forces for the liberation of Congo. This relates to his participation in those forces on the territory of Ituri region, as you mentioned, in the period between 2002 and 3, as far as I remember. He has surrendered himself to the court in 2013 after a couple of arrest warrants were previously issued against him. The trial started in 2015, in September 2015, and I'm reading because I wasn't aware, but it's close to 250 hearings took place, and over 2,000 victims were listed as a part of the proceedings. And after 3 years of proceedings, closing statements took place in 2018, and the judgment and sentencing judgment were both issued in autumn of 2019. The case is currently on appeal because both the defense and the prosecutor put forward the appeal, so we are waiting judgment on appeal in regards to this individual. Where my brief comes in, and not only mine, but several other experts who applied and were invited to submit amicus curiae briefs, was during the appeal proceedings after the prosecutions put forward their appeal. The court has invited publicly, public, if you like, to submit interest declaration of interest for anyone who would like to reflect on specific issues that relate to the substance of the case, and particularly substance of the appeal, to express their opinions. And following the procedure, a number of individuals were invited, or organizations were invited, to put forward their amicus curiae briefs. And I was one of them. And so, yes, that's where we are. So in a way, the court sought extra advice from the public, or public, let's say, maybe more learned experts in the area, to be able to reflect and have a more informed decision to take, which I think was a very welcome step from the court.
Right. Thank you for that overview. So I read your amicus curiae brief, and it talks about the meaning of the term attack and its associated context. So how do you understand the term attack in international law, and specifically in international humanitarian law? What is an attack?
Okay, so the court has specifically asked for a reference to which relates to the charges that involve war crimes. What this means is we need to distinguish the notion of attack from the way it's used to denominate a specific military operation during armed conflict, to another meaning of a word attack, which is used generally in the use of force, which means simply attacking one state by another, or non-state actor, and so on and so forth. So what I'm saying is the notion of attack has two meanings. One, which is very specific to the prosecution of hostilities during armed conflict, and that the meaning was at the heart of the appeal and the court's question. And so accordingly, in 1977, as a part of additional protocols to Geneva Convention, Article 48 has been negotiated that contains a definition that is widely used to elaborate of what the meaning of attack, of the word attack, is, and that comprises acts of violence against adversary, whether in offense or defense. So consequently, the meaning of the term requires that the attack must take place against adversary. And the meaning of adversary is broadly perceived to include not just human beings, but also military objects, military objectives, which could be physical objects as a part of the military infrastructure.
Right. So what are the key components of an attack that you have studied and described in this brief, and how is it differentiated from other terms that you have mentioned, like hostilities and military operations? How are they all connected, and what are the key things that we need to look for when we're thinking of an attack?
So attack as such, as the very heart, is the notion of act of violence. What does it mean? Well, it's a specific type of military operation that requires employment of kinetic force. Sometimes there is no actual kinetic force being employed, especially if we look at the debate about the meaning of attack during cyber warfare.
Yeah.
But what we all agree that even in that case, there have to be some sort of violent consequences of that use of force, and usually resulting in damage or destruction of the either functionality of the target, or well, their functioning, or them being alive, if we're talking about human targets. And so there has to be some sort of physical damage that will become a consequence of that use of force, or lack of use of force, but a violent consequence. to constitute attack. Attack, in the broadest, attack is a type of military operation. So military operation would be it's not a legal term of art, unlike attack, because it's not defined in the law of armed conflict or international humanitarian law, but it's a operational notion. Through looking at the various negotiating records for the additional protocol 1, we can infer that military operations are defined as movement of attack or defense by armed forces. So it's a quite broad category. Or it seems like a broad category, but what it means is that for the purposes of delineation it with attack, it might involve the term things like intelligence gathering or support or enabling of prosecution of movement of the armed forces, which don't involve use of kinetic force against adversary. So it's a broader notion to attack. Hostilities in this context, again, hostilities are not defined in the law, so it's more operational notion that we use among the legal experts, but also practitioners as such. But what it means is it defines hostile or threatening activity against the adversary in all forms, so long they somehow link to prosecution of military operations. In other words, for instance, there could be acts of violence which are not related to prosecution of armed force, military operations. For example, two members of military forces fight each other in a bar, totally unrelated to prosecution of military operations. However, there is a use of violence between them, but this will not count towards our meaning of military operations or hostilities as such. So we have to remember that in terms of hostilities, it's a broader, again, category to attack, involves prosecution of war, of armed conflict as such. I would define it because, again, number of experts place these notions, military operations and hostilities, in sort of different lines, slightly different lines. We all more or less agree where they sit, but to me personally, hostilities is probably the broader notion, but very much related to prosecution of war, whereas military operation can include not related to wartime prosecutions like training of military forces as well, perhaps a movement of military forces, not necessarily guided by the prosecution of war. And then within that category, attack sits as a specific tactical operation, I would say, maybe tactical, sometimes operational, depending on what attack is. But as I said, attack is different because it's actually defined by the law as well. So we know where we stand with that.
Right. You mentioned the definition of an attack under the additional protocol of the Geneva Convention, the first one, in terms of as defined as an act of violence against an adversary. So does an adversary also include civilians?
Yes, it can. Because again, adversary is not a legal term. It doesn't come with any specific legal meaning. Adversary could include civilians of, if you like, enemy. However, we do know that they are protected in most of circumstances against attack, if you like. So civilians per se, due to operation of principle of distinction in the law of armed conflict, will be protected from attack unless they take direct part in hostilities. And that's a totally different definition what that means. But adversary can mean individuals and persons, and that can involve, if it's seen broadly, civilians too. But there are protective rules in place to protect civilians.
Yes. So my next question would be, does the notion or meaning of an attack change depending on the nature of the object against which it is being done?
No. In short, it shouldn't. There's one definition that applies to whichever target you will like to attack, if you like. So what changes is how, or there is a difference, is how persons, as opposed to physical objects, are defined as lawful targets in the law. There are different guidance we have for what constitutes a military objective, which is referring to physical objects, or what will cause a civilian to lose their immunity based on their involvement in armed conflict, which is then, at this point, we would need to ascertain their direct participation in armed conflict or in non-international conflicts. This also involves certain level of membership in organized armed group, so on and so forth. So there are different rules that would define that, but bottom line is attack, when we're talking about attacking someone, there will be certain additional rules to ascertain precautions in attack, how the attack is going to be undertaken, the proportionality rule, the choice of weapons, the choice of time of attack. This is all technical, if you like, application of the legal norms in preparation to attack, but the very notion of attack stays the same. It has to be intentional use of force that will lead to violent consequences to the target.
Right, that makes a lot of sense, as in the status of the object does not change the meaning of attack itself. You also talked about the term destruction being an operational word which is not defined in IHL as such. So how do you understand the term destruction as different from an attack?
So some situations that involve destruction, specifically of property, private or public property, are actually regulated, in fact prohibited, unless certain conditions are satisfied in conflict. But the term itself, again, is not very much, it's not a legal term of art, it's not defined by the law. And so what the destruction involves, in common parlance, it would be defined as involving an act of violence that renders an object no longer usable, or that cannot be repaired to the point that we are unable to restore its primary function. For me, again, because we can argue what it means, for me, destruction itself, it leads to total inability of restoring or enabling that object or property to function again in the previous intended function for it. Damage is the word that I would use to describe perhaps a partial damage, where there is some scope or possibility to bring back that function after repair. So damage is not perhaps extensive or not always totally irreparable to the object. And that would be my definition, if you like, or understanding of these terms.
Okay. What about pillage? Does pillage and other similar acts of plunder and looting, does that constitute an attack?
So pillage, it's very different meaning to I would say attack or damage. Pillage, which we use also interchangeably with the word plunder, involves a activity that involves appropriation of the property. So seizing of kind of property, which as a part of that seizing and taking control over it, some damage or destruction can occur. Yes, but in its sense, in its very sort of defining moment, it's taking over certain property for private or personal use that will amount to pillage. So it's, in the very sense, it's very different notion to attack. Attack is intentional activity directed at either destruction of the target or their damage or they're taking control over it. With looting is or spoliation, it's the unlawful appropriation of a property. So you need to seize it in some ways. You need to take control over it and what happens afterwards, whether you destroy it, you use it, you abuse it, you leave it totally in the same condition as before. That happens after the act of pillage or as a part of act of pillage. But it's not like the destruction or damage is intended in the same way as with attack.
Right. So this criteria of pillage not intended to harm the adversary, but rather than benefiting the private usage or consumption of those who are undertaking it. Does this find any evidence in customary law or treaty law?
Well, the notion of pillage and plunder is actually quite developed and has a long-standing background in understanding already developed by International Criminal Tribunal for former Yugoslavia. We have several non-conflicting, quite clear references in the case law of what it means. And so the question that the court has asked, I think, in reference to the inquiry from the appeal was whether pillage can be considered as a type of attack. And so I would say, and that's what I did say to the court, my best opinion, pillage cannot be defined the same way as attack. Elements of use of force, of violence that leads to damage of the property might be present during looting or plunder or pillage, however you name it, but it's very much different action. There is no preparation to attack, such as you don't choose your weapons to the same extent, you don't gather intelligence to the same extent. The whole notion of undertaking attack is entirely different military operation. And so even more so in very structured, well-trained military forces, state forces, perhaps as opposed to non-state actor organized armed groups forces, where there might be some blurring of whether they want to undertake an operation. As a part of that operation, they undertake also pillage. But the preparation to what's broadly understood as attack, during attack, pillage can occur. Pillage is not the same as attack itself. Right. I would distinguish these two in this way.
That makes sense. What I was thinking, I was just that perhaps pillage may be conducted theoretically with the intention of harming the adversary, but as you said, it can fall within an attack it might not be a type of an attack. That makes things very clear. And I guess this entire discussion on the meaning of an attack and different terms that you have talked about, I think it makes for a very clear reading of how the court should interpret these different terminologies. In terms of the case, given that the final judgment on appeals is coming out tomorrow or today, depending on when this podcast goes out, how do you see that panning out?
It's tough call to say because court has put themselves in a rather precarious situation with this question. I appreciate court seeking advice for experts on the meaning of attack and what has been appealed by both sides in the proceedings. But what has happened was that a couple of years back, 2 or 3 years now, I suppose, in another case, Almaty case, the court has applied the same article that is now being proposed to be applied by the prosecutor in Ntaganda case as a form of war crimes to be applied in the appealed to operations, one involving seemingly looting of medical items, and the other one involving taking control of a church. The same article, which involves attack on protected objects, to be applied in the Ntaganda case, was applied to the destruction of property, cultural property in Mali in the Almaty case. The court there used the same article to sentence Mr. Almaty for commission of war crimes of attacking the cultural property and destroying it as a part of the Ansar Dine ideology against the local population beliefs and so on and so forth. That somehow has not been criticized enough, but what it does is sets a precedent for the court. Precedent which has been mentioned by the prosecution in their appeal brief, the suggestion that the court should rely on that judgment, on that finding, because it's already there as a precedent, and expand in the Ntaganda case even more the number of situations in which this particular war crime, as defined as attack against protected object, could be applied. This would set a very, very dangerous situation for both practitioners, military forces, states, and the legal experts, because this really leads to fundamental changing of the notion of attack, as we know and as military forces apply in the training of their members of armed forces and for planning of the operations which are regarded as entirely lawful so far, which suddenly maybe turn and have a criminal sanction if the court finds it as a war crime in this case. So it will not only lead to further fragmentation between international criminal law and international humanitarian law on the point of meaning, practical meaning, but also legal meaning, because as I said, this is absolutely vital. We do have a definition of what attack is in the law, unlike with other terms. And so the interpretation will lead to further fragmentation and separation of the directions on that one issue, absolutely vital issue for operations of military armed forces everywhere in the world. Not only that, this meaning of attack is customary in nature and is applicable to non-international armed conflicts. So the prevalence of non-international conflicts in the world, this will be setting very dangerous disparity of what armed forces known and practice without major problems in the global, in various armed conflicts, and to what the International Criminal Court may regard as a war crime. So they might start refraining from planning certain operations. They might need to restructure the training of the armed forces. They might look and take a position. Perhaps states will be forced to take more active position on reflecting whether they agree, because after all, court case law, whether we like it or not, could be advisory for the purposes of our understanding of laws of armed conflict, but laws of armed conflict or international humanitarian law, as agreed by the state, will be the one that will proceed. States might not notice the change in the law to that extent, and maybe they will get caught in not seeing that perhaps the court has put such a different meaning to what is a criminal sanction for certain previously absolutely lawfully undertaken military operations. Don't know, but from my perspective, I can see profound consequences, both in legal and operational terms, if the court decides to continue with the precedent from Al-Mahdi case. If the court takes different side and sort of listens to all the amicus, listens to the arguments, which I think pretty much are quite consistent. I mean, obviously we all legal experts, so we tend to disagree on certain things, but there's a majority, I think, of the arguments were consistent to my view, or my view was consistent with theirs. But what then it will create a situation for the court that they already have a judgment in one case against one individual, which might seem unjust now if they find for another resolution based on the same article, same war crime in the Ntaganda case.
Right.
And maybe the defense will have to revisit, of Mr. Al-Mahdi, revisit the final sentence on in Al-Mahdi case.
Yeah, so I guess what you're saying is the stakes are very high, and we'll see, and time will tell what implications this case has for the future of war crime prosecutions, international criminal responsibility, and international criminal law as a whole. So we'll find out tomorrow, and time will tell how that pans out. And yeah, it was a very enjoyable discussion with Dr. Agnieszka. Thank you so much for being on the podcast. I absolutely enjoyed it. Hopefully the audience would find this discussion very useful. So yeah, see you in the next episode. Thank you so much, Dr. Agnieszka, for joining us on the podcast.
Thank you very much. It was an absolute pleasure. And gosh, fingers crossed the court will resolve this one in a sensible manner for all of us' sake.
Yeah, let's hope so.